Lawyers of Reddit, what's your best most baddest, I rest my case moment? When I was in law school, I had to argue a case for an exam. I was the last in my class to go, so there wasn't anyone arguing against me. I opened with a motion to dismiss since opposing had failed to show. The judge grading me chuckled and said, "Touché, counsel." I still had to go forward, but we got off on the right foot and I ended up with an A. Not a case-winning moment, but a motion-winning one for sure. Think of cases like a big conflict, with motion hearings as little conflicts. Opposing attorney was insisting that Rule A meant they could do X. I tried, multiple times, to point out Rule A literally did not say that. During the hearing, the judge reached behind them, grabbed their rules of civil procedure, basically a dictionary of rules, placed it in front of the other attorney, and said, "Show me where Rule A says X." Other attorney did not take the hint, read rules out loud for a brutal 5 minutes, and gave the book back. I said, "Judge, I have nothing to add." It was pretty fun. I was prosecuting some kid. He had an antisocial behavior order, which meant that he was not supposed to go to a certain street. He had pleaded not guilty on the basis that he had not been there. I opened my cross-examination by holding up a map and pointing at the street. I said to him, "You went here, didn't you?" He said yes. In England, we don't say "I rest my case." Instead, I looked up at the bench, said no further questions, and sat down. It might not seem badass, but I got the defendant to admit the offense with one question. That never happens. Corporate lawyer, so I don't have cases to rest. But once opposing counsel was forcefully insisting that it was ridiculous for me to expect a certain provision in a contract we were negotiating, and I pointed out that this provision was standard in his own firm's contract forms, as I knew from several prior transactions I'd worked on across from them. Pretty exciting stuff. He took it in stride and said, jokingly, "Well, of course it's fine when we ask for it." The opposing counsel decided that I had coached my witness and gave him lines to repeat, that he was lying. Short version is that he asked the witness if he spoke to me before he testified. Witness said he had. Attorney looked like he thought he had me. Attorney asked the witness what I told him, what instructions I gave him. Witness looked him dead in the eye and said, "First thing he told me was to tell the truth no matter what." He said the lawyer is never the one who goes to jail, that he isn't going to jail for me, and if I lie, I'm on my own. Attorney looked like someone took the air out of him. Everyone in the courtroom simultaneously looked at me. Only time I've smirked or laughed in court. I wanted to put my feet up on the table like I was Vincent LaGuardia Gambini, hands behind my head, and say, "I'm done with this guy." Defendant in a bench trial for a speeding ticket said he couldn't possibly go as fast as the officer clocked him. He knew this because he videotaped himself accelerating from a full stop to the location of where the officer sat. His experiment showed his vehicle could only get to 55 miles per hour and not the 67 miles per hour he was clocked at. The ADA then moved to have another speeding ticket issued because the actual posted speed limit was 50 miles per hour. Guy in a divorce case transferred money to the Equity Preservation Corporation. I looked at the corporate filing, there were only 2 shareholders. Knowing who they were, I asked on cross-examination. He denied knowing them. I then asked about them by name. He admitted they were his parents. I represented a company that was sued for breach of contract by a former independent contractor. Dude basically alleged that my client wasn't paying him correctly in accordance with the contract. During his deposition, Dude admits that he never reviewed any documents to make sure his allegations were true, never reviewed his complaint before filing it to make sure the allegations in it were true, and had no idea whether or not my client actually failed to pay him in accordance with the contract. Basically, he tells me that he was suing my client because he didn't think their agreement was fair, even though he agreed to the terms when he signed the contract. The kicker is that he admitted that he owed my client money. At arbitration, he tries to flip his story and starts giving testimony that is the exact opposite of his dep, so I whip out his transcript and undermine his testimony bit by bit. Needless to say, I won that case. I annulled, but I was in traffic court one time and saw a lawyer straight up murder a cop with words. The cop had previously testified that the weather on the night of the traffic stop was heavy rain and winds so strong that the defendant could only open his window 3 and that the car had stopped on an area with very little shoulder, forcing the cop to approach from the passenger side, not the driver's side. The cop had then testified that he smelled a strong smell of alcohol on the defendant's breath. When the defense lawyer got up, he repeated what the cop had said almost verbatim and asked how he could have possibly smelled alcohol on the breath of someone on the other side of the car through a crack in the window on a night with pouring rain and strong winds. The cop sort of opened and shut his mouth a few times, squirmed around in his seat, and said, "That's just what I always write in my log to remind me that it was a DUI stop." The judge threw the case out. No motion to dismiss needed. Then he took a break and called the traffic prosecutor and the cop into his office. "I'm guessing it wasn't for a nice spot of tea and some scones." Edit. Really, people? You've never seen INL in a comment thread before? IP lawyer deep in a set of terms and conditions on a website, our client's details, name and contact details, were listed. So it is very evident that they just copy-pasted our client's legal terms and conditions and missed a couple of details they needed to change. I was handed the matter, did a quick Ctrl+F for client details, and it was an open and shut case. Not really that impressive, but saved me hours of time going through each term one after the other, noting exact similarities for a letter of demand. Complaining witness accused my client of harassment stalking. Said she told him numerous times that she wanted nothing to do with him. My client claimed they were dating, but whenever she got mad at him, she'd call the police and say he was harassing her. On the stand, she testified that she'd never dated him, never invited him into her home, wanted nothing to do with him. She presented a photo on her phone of him sitting on her porch to prove that he had come to her property. I asked the judge permission to look at the photos before and after the porch photo for context. Girl had dozens of photos of the guy, who was clearly her boyfriend. I showed her one such picture. "This is Mr. So-and-so, right? Yes, in this photo, he's on a bed? Yes, the bed is yours? Yes, the bed is in your bedroom? Yes, you took this photo of him? Yes, he's smiling in the photo? Yes, and in this photo, he's wearing your brassiere? Yes, no further questions, Your Honor." I do mostly solicitor work, so if I'm doing my job right, I don't get a whole lot of these type of moments. That being said, I had a long-time client who was being sued, and I got to shut down the guy suing him in a very satisfying way. So my client had hired a guy, we will call Kevin, as basically a right-hand man for his company. The employment contract wasn't done yet, but they had an agreement that Kevin would work 6 weeks at a lower wage and then sign the contract and get the agreed-upon wage. So the guy works decently for 5 weeks and then is given the contract to sign. He comes back to the owner, my client, and says that he has some small changes he would like to make. When the owner gets the contract back, he finds that the small changes involve removing the duties and responsibilities section, basically the job description, and the non-compete confidentiality clause. Not only that, but he has written in a higher salary than agreed and added a bunch of new benefits for himself. Obviously, my client tells him that he can either sign the contract as it was originally laid out or he can find himself another job. He takes the latter option. But he starts a lawsuit against the owner wanting to be paid for the 6 weeks he was supposed to work, which had already been paid, 2 weeks in lieu of notice and 5 weeks vacation pay. I got the enjoyable job of telling Kevin, in front of a judge, that he was not entitled to anything under the employment legislation, and the only way he could get any of that would be if he had signed the contract. Judge dismissed the case and awarded costs to the defendant, but not before giving Kevin a lecture on wasting the court's time. Not a lawyer, but during a particularly nasty employment mediation hearing, I got to ask my former employer a question about payments per employment law. Me. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence mediator. Sir, answer the question. Silence mediator. Well, let me ask it. Did you or did you not pay into state-mandated unemployment insurance fund for all your employees past and present? Silence mediator. I'll take that as a no. I'm not a lawyer, but the most memorable court scene I witnessed was 1968, Sacramento, CA. I was waiting to be tried in traffic court, my usual speeding, before Earl Warren Jr., the son of the great Earl Warren of Supreme Court fame. The guy before me was being tried for reckless driving. When it got down to sentencing, Earl Warren Jr. ordered some nominal fine and that the defendant attend traffic school. The defendant got all upset and began ranting how he didn't need to go to traffic school. As the defendant slowed down, Earl Warren Jr. calmly stated, "Well, sir, I cannot make you attend traffic school. I can only issue the order for you to attend. If I find after 2 weeks you have not attended, I will issue an warrant for your arrest and place you in county jail for 30 days. At the end of which I will renew the order for you to attend traffic school. So we can keep you going in and out of jail until you decide to attend traffic school." The guy just grumbled and walked out of court. Don't know if he did go. I certainly did when I got a similar sentence. I'm relatively junior, so I'm hoping to beat this one day. I defend professionals and brought a motion to dismiss a case on the basis that the plaintiff could not prove my client was negligent as she had not served the required expert evidence. As opposing counsel and I waited for our motion to be heard, we were sitting in the courtroom. The judge, who I did not know and who had not read our materials, wanted to talk to the parties of a short trial, which was to be heard after our motion was argued. That matter was also a professional negligence matter, and the plaintiffs had no expert support. The judge then spent 10 minutes explaining that he had practiced in professional negligence for many years and was well versed in the evidentiary requirements to prove the elements of professional negligence. In fact, he said, I very rarely use the word impossible in this courtroom, but it is impossible for you to be successful without expert evidence. Our matter was then called and I reveled in explaining to the judge that he was about to hear a motion to dismiss a professional negligence case on the basis that the plaintiff had no expert evidence. I won. Terrible people had stolen all of this little old lady's money. They said it was a gift, but their only evidence was a document in the BD person's handwriting that was allegedly dictated. It said September 2012. No day, just a month. Clearly the rogue had forged that when she found out about the lawsuit and, not remembering when she had stolen it, she hoped if she could guess within the month, no one could challenge her. So I'm questioning her about it. Exhibit B is the little old lady's bank record. Now that withdrawal at the bottom, is that the alleged gift? Yes. Can you read the date of that transaction for me? August 25, 2012. Thank you. It wasn't a trial, though we had one of those and I won it easily. Just always stuck with me because of how clearly the law supported my position to the point that it was inarguable otherwise, and also because of how ridiculous the claim of monetary damages was. Guy moved out of his apartment, turned in his keys, then came back 15 days later demanding access so that he could retrieve belongings that he had left behind, which at that point had been trashed. It was just some minor furniture type items, lampshade is the only thing I clearly remember, and a box of his college notebooks, i.e. notes he took during class. He is furious and sues the landlord and small claims for $5,000, state maximum, because his notebooks have such huge value apparently. They hire me and I respond, which moves the case out of small claims. It's just the way it works here after time in our legal advice. I know this is not the case for every state, but our rule is better than yours, but enough aside. This puts him at a huge disadvantage because now he can't rely on the lax rules of small claims, so he goes out and hires a lawyer. The lawyer calls me to try to talk settlement. I know her pretty well, so I wasn't rude or anything, but I kind of scoffed and was like, no, that won't be happening, and direct her attention to a particular state statute, then read it out loud to her. This statute, unlike everything else in the law, isn't overly long or wordy or hard to follow. It just says bluntly that when someone actually moves out and gives notice of this, items left after 10 days are abandoned, period, end of story. I could feel her deflate on the phone and encouraged her to dismiss the suit. She did not. We proceeded to a short bench trial in district court that we won. Ace attorney here. A parrot testified once and helped defend my client and convict the right person. I once had an appeal where the precedent, all from other circuit courts, was very bad for me. The circuit court I was arguing in front of had a decision that was very good for me, but it was unpublished, meaning that it was not precedential. My goal was to convince the court to follow its unpublished decision, not the decisions of the other circuits. During my argument, I cited the unpublished decision. One of the judges interrupts me and asks, "But wasn't that decision unpublished?" I answered yes, but it was well reasoned. He replied with a self-effacing quip, "I was on the panel for that decision, so it couldn't have been that well reasoned." The audience laughed a bit. I answered quickly, "In that case, Your Honor, it was at least well written." The audience and all the judges burst into laughter. I ended up winning in a published decision, which turned the old unpublished decision into binding precedent. A bit of humor can go a long way in the courtroom. Especially when you're flattering the judges. I had one where I pretty much knew the jury was on my side by the end. I had prepared my closing statement the night before, so I was ready to go. There was a break where the jury was out before receiving their instructions. I noticed that the opposing counsel was writing his closing statement during that break and would likely continue while judge was reading the jury instructions. His table was a mess, papers and books everywhere, and he was frantically scribbling on a notepad and shuffling through papers, adding things up in a phone calculator, etc. I decided to clear everything off of my table and put it out of sight. When the jury came back in, I just sat there with nothing but a brand new, clean yellow legal pad and a pen. Opposing counsel was still scribbling and shuffling, and his table was still a mess. I sat back and crossed my legs and pressed my fingertips together and listened while the judge read the instructions to the jury. I like to think that made a good final impression on the jury. They came back with a verdict fully in my favor. The third party my company hired is being sued for violating national do not call laws. We received a document third party wanted to settle with customer. Our lawyer. This document doesn't name us, so tell them it's fine to sign. If they want to settle 100% on their own, they can go for it. Me. I'll, but from what I read, we are vaguely mentioned at sentence 3 and then by name in sentence 5, 7, 13, 17, and 21. Our lawyer. Oh right. Force them not to sign it as we have to figure this out on our side. These are the people who make 5x what I make and charge $800 per hour to not even read the first paragraph of the settlement. My client and his wife were woken up one night because people were trying to break into his house. He fired 2 warning shots as his wife called 911. The neighbor also called 911. When the police got the neighbor's call that there were shots fired, the police sergeant radioed the other officers and said, "He's going to jail tonight," referring to my client. So obviously, even with signs of someone trying to break in and his wife calling 911 for help, the officers arrest my client for endangering his wife by shooting inside the house, nowhere near her. It gets to a jury trial and I start to go off on the police sergeant about why she would say that before an investigation and before she even had any idea what happened. The sergeant had no idea how to respond and literally just sat there staring at me for a solid 2 minutes before saying anything. Even the bailiffs were audibly laughing. As someone taking my former employer to an employment tribunal, one of the parts they denied was the base roster of days based at 724 mins. My barrister said, "Well, why do all of your rosters and pay records have that as a base day?" They denied it. My barrister turned to their legal guy and said, "So these papers from HR that show all pay records for my great are based on a 7-hour 24 min day?" He said, "Yes, they do. Edit 724 paid and booked 8-hour days." I helped the prosecution rest his case. Lol, I got jammed up during spring break doing dumb spring break shit. So there I was in court to face the music, misdemeanors. As I sat there waiting for my turn, I watched person after person go before the judge. The prosecutor read their charges and some information from the police report, stating what the potential max sentence was for each. I don't remember exactly. Then the judge asked what plea they wanted to enter. Almost everyone said not guilty, and I could see that both the judge and prosecutor were getting tired of their bullshit. Finally, my turn came. I was probably second to last after what seemed like hours, but may not have been. The prosecutor read off my charges and cited the police report. The judge looked at me with this, "Let's just get it out of the way. Tell us you're not guilty" look and ask how I pled. "Guilty, Your Honor." The judge and the prosecutor both looked at each other, and the judge said, "Kid you not, say again? Or beg your pardon?" "Guilty, Your Honor." "I did it. Just the way Officer so-and-so's report reads." They exchanged looks again, and the prosecutor held his papers at arm's length, as if to get a better look at them, and did the unthinkable. "Your Honor, this all reads to me like a case of college prank gone bad. The county moves to reduce charges to XYZ. I walked in there expecting some jail time and walked out paying like $110 plus costs. I didn't really know how to feel about the scariest day of my life turning into one of the happiest ones. So I'm fighting a DWI case, and the cop is a lying liar who is telling big lies about what signs he saw on the field sobriety test, that my client was allegedly intoxicated. The state had not moved expeditiously enough to have a copy of all of the evidence in the case. So we got him up on the stand talking all about how my clients looked on the horizontal gaze nystagmus eye test, then buried him with his own body camera footage which he thought had been destroyed. It wasn't. The judge, the newly elected Democrat in Texas, made findings on the record that the police officer had intentionally lied and misrepresented the truth. The state still tried to fight the case, but it came out the right way. I was trying a criminal sexual conduct case. My client was a stepfather of a 13-year-old girl and an 8-year-old boy. Allegedly, my client fingered her on the living room couch while the 8-year-old boy was in the room with them, watching TV. Mom was in a rehab facility for drug and alcohol abuse. My theory of the case was that the girl made the case up because my client refused to pay for modeling classes for the girl. The boy testified and said he saw the criminal act from where he was sitting on a recliner. On cross-examination, I asked how he could see what happened since the lights were low nighttime and my client, who is 6 foot tall and weighs 200 pounds, was in between them. He said that his story was what he was told to say by the sister and the prosecutor's victim coordinator. The prosecutor rested her case. I shut up and sat down. I presented no defense, and it took the jury 3 minutes to find him not guilty. In summing up, it's the Constitution, it's Mabo, it's the vibe, and no, that's it. It's the vibe. I witnessed this sitting in court. It was a drug case and there was some discussion between the prosecutor, defense attorney, and the judge about the quantity. Judge says something like, "Right, but that's in ounces. How many grams is that?" Prosecutor and defense attorney say they don't know. Judge says, "I mean, we can figure it out, how many grams are in an ounce?" Prosecutor and defense attorney still shrug, like dunno. All of a sudden the defendant pipes up, 28.3. Two high school kids spend their day pissing each other off, so they decide to drive to a fast food restaurant to fight. They park, get out, immediately approach, and swing. Kid A connects the first blow squarely and solidity across Kid B and instantly drops him. The whole fight was one punch with a total elapsed time of a few seconds. The restaurant is sued for failure to protect its patrons. The case is weak. Unfortunately, Kid B hit the pavement hard and had severe brain damage. Attempts were made to settle, but they were after millions. We knew walking in they had two former employees testifying about large crowds building up after school. The plaintiff attorney aimed to prove the restaurant had a reasonable expectation of trouble and should have had armed guards in the parking lot. At best, their witnesses wildly exaggerating to the point of perjury. Their credibility was shaky and being highly disgruntled for being fired. We had a list of witnesses ready to refute their claims. At trial, the plaintiff attorney presented first. He spent a long time building up the bad blood between the kids, the serious damages of Kid B, and his potential earning capacity. A lot of foundation work to build sympathy for his client. We break for lunch on day 2, after which it would be the defense presentation. As we were talking through where we were and how we should proceed, we realized the restaurant was not really mentioned at all. Plaintiff held back his star witnesses to rebut the defense presentation the restaurant was safe. So when we reconvened, defense rests, Your Honor. The plaintiff attorney fell out of his chair. He begins frantically shuffling papers on his table and was stammering. The judge says, "I take it you will need a few minutes for your close." After that break, plaintiff's attorney gave one of the worst closing remarks I've ever heard. Jury. Kid B 10% at fault. Kid A 90% at fault. Restaurant 0%. My brother-in-law is a DA. He was attacked during sentencing by a child molester. The pedo got his hand chains around his neck and was choking him. My brother-in-law fought until the deputy pulled him off, then continued with his recommendations like it didn't happen. We all heard about it on the news later. When we asked him, he said, "It was no big deal. I'll take the bruising if it keeps him away from kids longer." My brother-in-law had bruising to his neck, throat, and his voice was messed up for about a week. Obligatory, not a lawyer, but I was defending myself against a debt collector for a debt so old I could not even remember for sure that it was mine. Me to the debt collector. "Can you provide the actual contract bearing my signature along with a chain of title to the debt?" Debt collector's lawyer. Crickets. I look at the judge. Judge to lawyer. "Well, can you?" Debt collector's lawyer while looking through paperwork. Well, no, not at this time, Your Honor." Judge. Case dismissed. Note. To prove that a debt collector owns your debt, they must prove how it came to own it. Often, old debts are sold and resold over and over again to a number of subsequent debt buyers. When this happens, the debt collector must prove each and every assignment by showing a chain of title reaching all the way back in history to the original creditor. More often than not, for old debts, it is impossible for the collector to show this. Anytime you win a motion for a judgment of acquittal is pretty fun. An MJOA is a motion the criminal defense attorney makes immediately following the conclusion of the prosecution's case. The motion is essentially saying, even if you believe all of the prosecutor's evidence, including the testimony of their witnesses, you still cannot convict my client. I had a case recently where the prosecutor failed to establish that the incident occurred within the court's jurisdiction. So, because the prosecutor failed to ask its witnesses, where did this occur? Or something along the lines of, did these events happen in X county? I win. It feels like a gotcha tactic or exploiting a loophole, but I can almost guarantee that the prosecutor won't make that mistake again. Also, it is a great feeling when the state rests and you know you have the trial in the bag. An ex of mine read a Reddit comment of mine making fun of her tattoos that, ironically enough, she braggingly posted to bad tattoo threads, so I don't see what the big deal was. In retaliation, she filed for a restraining order alleging sexual assault and rape threats. In her written allegations, she straight up admitted that I don't have contact with her, that I'd spent most of the last year living 2,000 miles away from her, and that the only time she'd seen me in the last 2 years, I deliberately avoided her. If that weren't enough, on our day in court, when the judge asked her what threat I represented to her safety, security, and privacy, she said, nobody should be able to say that about her tattoos. She literally forgot about all the made-up sex offender stuff while talking to the judge. When I got Dennis to agree that believing in science was equal with believing in the Bible, and all my friends who believed in evolution were on the fence afterwards. Wasn't really I rest my case moment, but it was a good one. A few years back, my brother and I moved into this quiet apartment building. The property managers catered to the helicopter pilots who lived above us. Meanwhile, my brother and I were correction officers at the time. We kept getting the blame for our loud neighbor. Had a shitty day at the jail, come home to find an eviction notice on our door, stating that we have 10 days to get out of the apartment. We stayed and hired a lawyer for the tribunal hearing. Our lawyer during the hearing, I understand you have helicopter pilots living in the building. Well, these gentlemen are correction officers and have to be up early in the mornings as well. Are you telling me their jobs are not as important? The two property manager ladies were stunned with that question. Lawyer continued, so if we follow through with this eviction, we have to get all the complainants to take the day off of work to come in for this? Are you willing to make these people do that? The two property managers were totally unprepared for this guy. The tribunal guy was even impressed. Felt pretty good to beat them at their own game. The two managers asked our lawyer in front of us and the tribunal guy, if we ever have any more issues with these two tenants, can we hire you? He kinda chuckled at them and said, I fight for the little guy. My 8-word trial would be up there. Basically my lowest ever effort court hearing win. I was required to say a grand total of 8 words during the whole thing. The defendant's lawyer has fucked up spectacularly and has tried, ineptly, to get his client and himself out of the shit. He spends about an hour ranting and raving about the injustice of it all, screaming at the judge that he's got it wrong, while I sit, half listening, casually browsing Reddit using the court Wi-Fi. Eventually, he gives up, and the judge says something like, for reasons I'm going to dismiss this application. Anything to add, you counts apply? No. Word 1, okay, application dismissed for reasons. How much are your costs? £12,000 plus VAT UK sales tax, words 2 to 6, granted. Good morning, thank you, words 7 and 8. Was waiting with now ex-wife in divorce court. Ours was mostly mutual, so it was somewhat painless. The couple before us was an older divorced couple arguing over back child support. Her. He has not paid me in 3 months. I gave him an extension but still nothing him. I don't have any money right now, times are tough. I'm trying the best I can. Her. You honor ask him where he was 2 weeks ago. Judge. Where were you 2 weeks ago? Him. I went to Florida and got remarried on the beach. Bailiff. Click. Click. The guy was hauled away in cuffs. I'm not an attorney, and it wasn't in front of a judge, but I got into a dispute with a contractor who fucked up royally when installing a new heating system, resulting in an asbestos contamination of my house. Their insurance argued the contractor couldn't have caused the contamination because the contamination was way worse than could have been possible from what the contractor did, which is bullshit. They argued the contamination must have been caused by the contractor that installed the previous heating system. It was super satisfying to write our response. 1. The previous heating system was placed 12 years earlier. The asbestos dust was visibly lying everywhere. Arguing we didn't vacuum for 12 years was beyond ridiculous. 2. The asbestos dust was on a floor we installed 6 months earlier, included the receipt for the floor. And then the third point was the most fun to write. 3. I said they were welcome to believe the contamination was caused by the contractor who installed the previous system 12 years ago. I included the receipt of that installation. It was done by the same contractor. The next letter was very brief, stating they would pay us for all damages we were claiming.